Welcome to your favorite program, the University of the West Indies and You. You always look forward to that program on the third Thursday of each month. This is the month of March. And let me just say that I'm probably in the hands of the law, or partly so. I have today two special guests, one who you will recognize as a Dominican, providing he doesn't talk Creole. And if he does, we may think that he's from our sister island, St. Lucia. But definitely there is someone from St. Lucia with me. And as usual, these gentlemen will introduce themselves and tell you why they are here with the University of the West Indies and why am I referring to some legal procedures and things that you may say that help the legal procedure in each jurisdiction in the Caribbean. And Dominica is no exception. As always, you are curious, like I am, to hear what they have to say about mediation. That is what we're going to be dealing with today, mediation, and how is the University of the West Indies involved in that exercise throughout the, let's just start with the OECS, but throughout the Caribbean, that is happening. And you will hear from these two gentlemen. I wish really we had a lady here, because usually when I speak with persons involved in law, you can recall Cynthia Barrow-Giles and others have been there. We have always had a female to discuss matters related to law. But as always, sit back, listeners and viewers, and enjoy what the University of the West Indies Open Campus Dominica site has to offer. A lot is in store for you.
I'm part of a tough, smart,
constantly evolving,
never too old to learn community of human beings.
proud of country,
Proudly Caribbean, global citizens.
with convenient access to over 400 learning programs
Delivered both online and face-to-face.
from the Caribbean's University of First Choice.
My mind,
My life.
my world of possibilities is wide open.
Call, click, or visit the UWI Open Campus.
Gentlemen, welcome to Dominica, Mr. Francis Compton. You will have to say, because always a guest on this program has to say, what is your background? What's your interest? It's almost like, what is your life? You would have to tell the general public in Dominica. Si vous voulez parler en petit créole, you can. You're permitted to do so. And the registrar, he'll reveal himself, but we all know him. The registrar is also with us, and he's, I think, 100% Dominican, or is Walsh coming from some European territory? The registrar may be partly Dominican, but the major part. Is that a true statement?
Entirely Dominican, sir.
100% Dominican.
But the surname is Irish.
Irish, oh, well, I made a guess. I know somewhere in Europe. I didn't want to venture.
Yes.
My name, Wilson. I would say Scotland, but you are from
Ireland. Northern Ireland in particular.
And Compton, most likely from England. There you are. Well, we are free Englishmen. We are free Creole men. And we are going to discuss the topic of mediation. What is mediation all about? But before we do so, Mr. Compton, welcome to Dominica. You are no stranger here. You have been to Dominica before. Tell us who you are, what you do, etc. Everything.
Yes, my name is Francis Compton, as you have indicated. I am the regional mediation coordinator with the OECS. In 2002, the OECS introduced mediation as a pilot project, and the pilot started in St. Lucia. And after being trained as a mediator, I was appointed to be the regional coordinator so that I could assist the court in replicating the program throughout the 9 states and territories of the Eastern Caribbean. Just a little very brief background. and if I'm permitted to do so, I spent several years of my life dealing with Social Security in St. Lucia and in the Caribbean, and during that period I made many friends in the Social Security office in Dominica and Dominica generally. So if I'm permitted to extend my best wishes to those of my friends who are still at the Social Security office in Dominica, this trip has not allowed me time to visit the Social Security office, so I'm doing it through this media. But my main concern is mediation. This has been my life, more or less, for the last, how many years? 12 years or so, from 2002. And all I do is to go around spreading the good news and the value and importance of mediation. And we'll have a little bit more of that, I appreciate.
And he also forgot to tell you, I always reveal the true identity of my guest, that he is an entrepreneur. He owns a motel in close to Fiji. Whenever you go for your Schengen visa, that is the place to go. So you got some advertisement there.
Thank you very much.
It's very close. Within 5 minutes or so, you can get to the embassy at Fiji if you live at Compton's residence. What is the name of that?
It's called Casa del Vega.
Casa del Vega. Spanish. I would have thought it would be Cai de Compton, but Casa he chose as being Spanish.
My wife deals with this, and she has absolute control over all
and I should also tell you, his wife, I think, is Vincentian.
Vincentian,
well,
yes.
There's no Spanish roots there, but we'll know a little more about that. I will help to mediate that concern.
If needs be, eh?
If needs be. Mr. Walsh.
Well, I'm no stranger to the Dominican audience. I'm Ossie Walsh, I'm the Registrar of the Supreme Court, but I'm also the Dominica's Mediation Coordinator on behalf of the Eastern Caribbean Supreme Court. The mediation coordinators are appointed by the Chief Justice of the Eastern Caribbean Supreme Court. So each island of the OECS has a mediation coordinator, and each coordinator coordinates activities with respect to mediation under the auspices of the Eastern Caribbean Supreme Court, which is, and the regional mediation coordinator is sitting to my right. So we work closely with Mr. Compton with respect to mediation activities. I don't have to speak too much about myself, and the audience knows who I am. But I just wish to say that mediation, if you would permit me, Mr.
Well, even before we go into defining mediation, which you will do, and you both, you and Mr. Compton, you are just to do just that, to elucidate the public on what is mediation all about. They may think it's almost like meditation, but we'll find out a little more as we go along. I just wanted to ask Mr. Compton, what role does the University of the West Indies have to play in this? Because that is a major interest for us,
yes,
who work for the University of the West Indies, and the University of the West Indies belong to us, the very region that we live in.
That's a very timely question for two reasons. Because my presence here over the last couple of days, the last 3 days, was actually funded by a project which is run out of the University of the West Indies based in Barbados. And Professor Velma Newton, who is responsible for that project, was actually here in Dominica for the first day of the project, and she actually came and visited with us to discern what it is we were doing in terms of a refresher course that we were putting on in Dominica, which ended yesterday evening. But the more important thing is that a couple of years ago, the OECS and the Judicial Education Institute of the Eastern Caribbean Supreme Court entered into a memorandum of understanding with the University of the West Indies based in St. Augustine, Trinidad. And what is happening now with us and the development of our mediation program is that the University of the West Indies has selected an officer of one of their tutors to work with me in doing mediation workshops, practical mediation workshops throughout the OECS. And they provide the assistance, and we work with them.
That is, they meaning the University of the West Indies?
University of the West Indies. And the good thing about this is persons who are being trained as court-connected mediators now, they've got their certificates accredited by the university. So certificates issued to persons who do mediation training with the OECS will have on their certificates not only the logo of the JEI, but they will also have the logo of the University of the West Indies, and the certificates will be signed by the University of the West Indies and also the JEI, the Supreme Court.
Supreme Court.
So the university is playing now a very vital role in the spread of our program. They came on board pretty late, but because in the past we were doing it only through the JEI, but now that we have accreditation, which is a good thing for persons who are trained as a mediator, and we recognize that the skills and the profession of mediation is growing throughout the Caribbean.
Okay. And Ossie Walsh, who is a graduate of the University of the West Indies,
that's correct.
like myself, should know any accreditation given by the University of the West Indies, any endorsement on a certificate, that has currency and value, because you have to work very hard for it.
That's correct.
And that is why that liaison with the Supreme Court of the OECS and the University of the West Indies is just what you need if you want to be a mediator. But let me now ask Ossie Walsh to define mediation. Mr. Compton also will do the same, and they may have different perspective. One, bear in mind, is a trained lawyer, solicitor, now the registrar of Dominica, but Mr. Compton came from the social security background and other background, business background too. He will have a different or similar perspective, but with a different twist. Yes.
Good question, Mr. Chairman. Thanks. The concept of mediation is not something that is new. Just think of any dispute within a family, within society, where you need some neutral umpire, someone to come in to seek to settle the matter. First of all, to grasp an understanding of what's going on with respect to the parties, and with respect, in a view to seeking to resolve the matter. So someone who is neutral coming in. So that concept is not new. What the court has done is to ensure that persons who are those neutral umpires are sanctioned by the court. So those persons who are sanctioned by the court are persons who would have gone through a process of training. And that's where Mr. Compton comes in, and that's why we just completed the 2-day refresher course in mediation to ensure that persons who act as that neutral umpire, that person to seek to settle dispute between two parties or more, is someone who is trained and versed in matters with respect to the court, and those mediators are appointed by the Chief Justice. So mediation really is a dispute settling mechanism, which is used by the court. It is court connected because the mediators are appointed by the court, and this medium is used to settle dispute between parties, and rightfully so, because a number of litigation matters go to the court. And when you look at those matters, a lot of it, many of it can be emotional, a lot of emotional part of it, people bringing their emotion into disputes, and you have to be that person who can discern, as it were, the facts and separate the facts from the emotions, and do it in such a way that both parties don't feel aggrieved in any way, and seek to arrive at a resolution of the matter in a very impartial way. So it's a skill which is acquired through training. You become very versed at it the more you do it, and we have some very good mediators there, and I can openly say one of the best mediators we have there is the person of Julian Johnson, who has done a tremendous job with respect to mediation in Dominica. And not only in Dominica, in the region. His skills is used otherwise. We've got about 20 mediators in Dominica appointed by the court. And a number of them, in addition to Mr. Johnson, we have people like Joan Prevot, we have Singwala Blomquist-Williams. Not only lawyers, by the way, are mediators. Mediators are drawn from various spheres of society, and they can bring up that skill to deal with disputes that come before the court. So it's the court, really, that sanctions the mediation activity. So the matter has to be a dispute which is being litigated in court, and the court, looking at the circumstances of the case, decides, well, this is a matter which could be successfully resolved at a mediation level, which is within the court's purview, but really outside the litigious route. Okay. And if it's not sanctioned there, if it's not resolved there, it gets right back on track with respect to the litigious activity and trial. So, okay. Yeah.
So there are several issues that Mr. Ossie Walsh raised. When he made mention of umpire, and some people may be thinking that we're discussing cricket. And now West Indians are grieved whenever you hear the word umpire and cricket. We're not doing too well, you may say, in the World Cup. Mm-hmm. But Mr. Compton, you are not a lawyer, and we did hear Mr. Walsh say that not all mediators are lawyers. Several persons are mediators, and they never did law. But in St. Lucia, I understood you have more than 200 compared to our 20 mediators. Tell us, in defining mediation from, should I say, layman perspective, and more so the coordinator, so you are very well respected. Tell us, mediation.
Okay.
And sorry, and there's something I'd like you to address. Can mediation take place before one goes to court, etc.? And because Mr. Walsh made mention of family disputes, I would think that if I'm trained as a mediator, I could probably solve a lot of disputes before they reach divorce. Huh?
That's right, sometimes.
Yes, Mr.
Okay, so we have been talking about mediation, but what I would like to do slightly is to broaden the definition a little bit, in that there are several methods of dispute resolution, and dispute resolution for us comes under a broader umbrella we call alternative dispute resolution, because hitherto the only way we had to resolve disputes was through the courts. That is why the word alternative came in. But I want to bring our minds back several decades or several centuries ago, before things become as modern and approaches as modern as they are today. Although we had not coined the phrase mediation or dispute resolution, all disputes in Indian countries and African countries were resolved around a fire, around a center. And the senior person in the village would listen to problems exposed by different parties. And that senior person would listen intently and work with those parties in order to resolve their disputes. In modern times, we found that that approach was dispensed with, and we found law courts came into being, and all disputes were channeled through law courts, whether it be a lower court or a higher court and what have you, or a court of appeal, what have you. What is happening now is we're finding more and more disputes in the world are being resolved by way of some kind of alternative method rather than the courts or rather than the barrel of a gun. We can just think of what is happening in the world today and the news which is quite current and the efforts which are being made to avert a third world war. And we can say that up to now, the efforts have prevented a third world war. And a lot of this is done through, we call it diplomacy, we call it mediation, we call it conversation. What we're doing is to get people to talk one with the other. Now, the court had at its disposal the avenue of arbitration, the avenue of conciliation, the avenue of negotiations, and mediation. And the court, in looking at all these alternative approaches, the court determined that mediation was that method of dispute resolution that the court would prefer. And the court then, in practice direction in the OECS, agreed that masters and judges would recommend to persons who are in dispute that they seek to resolve their dispute at mediation. But at the time the court took that decision, the court recognized that there were no persons trained in mediation within the OECS. Now, the court then sought to develop a training program in order to train persons in each of the states and territories in order to help the court not only to clear some of the backlog in the system, but to work on current cases so that the court will be assisted in dealing and disposing of matters. At the beginning, when mediation was introduced, there were several pundits of the law who felt that that system will not work. And the question was, how do you expect a layman with no legal training to deal with and or resolve a dispute which has been in the courts being dealt with by trained lawyers and judges who have spent a long time trying to resolve the dispute? How can you expect a layman in 3 hours or 4 hours to resolve this dispute? And a number of persons did not buy in the program or the process in the initial stages. With proper training, with adequate training, gradually the courts discover when matters were sent to mediation, matters were being resolved. And gradually, members in the court discovered, yes, this process can work. And if we give it a chance, it will help us. And this happened gradually over a period. And within a short time, in less than a year after having introduced mediation as a pilot in St. Lucia, and after my appointment, we showed that we could have replicated the program in all the other 9 states and territories.
Okay.
And that is why we have mediation programs in each of the 9 states and territories within the OECS. Now, I want to go one stage further. I keep talking about the OECS and our mediation program, which we started as early as 2002.
Pilot program in St. Lucia, 2002, yeah.
And we've been doing mediation non-stop up to now. And as I mentioned earlier, it is also replicated in all the 9 states and territories. Now, we have done not only the training, but the retraining of persons in all the 9 states and territories. The point I want to make and to clarify certain issues in people's minds, because some people may have a misconception. In the OECS, the Chief Justice at that time thought it would have been the best thing the quickest thing, the fastest thing to introduce practice directions so that we could introduce mediation quickly, swiftly. And the Chief Justice is the person who's got the power and the authority to issue such practice directions, including the appointment of mediators and chairmen of mediation committees and so on. Yeah. But the difference is in some territories, and people may want to ask about that, in Jamaica and in Trinidad within our region, they introduced mediation by way of legislation. And the legislation in most of these territories initially, because that's where the mediation started, in the community, with the police stations and in villages and so on. We, on the other hand, started our mediation program straight through the courts. When we trained persons, they were trained to operate immediately at the level of the court. That is why we continue to call it court-connected mediation. And we have not seen in the OECS up to now the necessity to introduce legislation to give anyone mediation authority. It's all done through the practice.
Well, on that point, I'd like to bring in Mr. Walsh, because as registrar, he should be monitoring what you have been asking for. That is, like Jamaica and Trinidad, the OECS, with his colleagues in the region, should be looking to incorporate that into our law. Yes, that is where mediation is not only observed, but is practiced, as he said, to reduce, one, the backlog of cases in court, but also non-court related matters can be dealt with by mediators. Mr. Walsh, it has implications. One, the law, which has not yet been passed in the OECS, and two, for lawyers or solicitors in the OECS, what implications that if we had several trained mediators, what implications it would have for those lawyers? But I'd like him to comment, because, because following the break, we will then be asking about the mechanism of thing, and also more about the persons involved.
Yeah, but let me hear his views. I wanted to make something clear, if there is any doubt. Please forgive me. Sure. As far as we are concerned in the OECS, the mediation program has been working well for the last 10 years plus. And all that happens under practice direction. There is no need for us to introduce a law to allow for mediation.
Okay.
Because the courts have already instituted that as a program of the court.
Yeah. But introducing a law would make it more uniform and manageable, no?
Not necessarily, because it's being managed.
So
the practice direction has put into place all the mechanisms.
And we all adhere to that.
Absolutely.
We don't need law. Yeah. So Mr. Walsh?
I think essentially that's what I was going to say, that practice directions are rules of court. Yes. When we speak of practice directions, we refer to rules of court that are sanctioned and ordered by the Chief Justice to use as procedurally to deal with mediation activities administratively and functionally within the court system. And those practice directions are to be strictly adhered to. In a similar fashion, when a law is passed, the law is passed by Parliament. Parliament passes laws in the country. And those laws have to be followed and implemented. Practice directions rules of the court. You can say, quote unquote, laws of the court. And those have to be strictly followed too as well. One clear one is for a 45-day window within which, that's what the practice direction says, or the rules say, says within which that mediation is supposed to take place. Mind you, the judge or the master who is so ordering mediation can always give it up to 90 days and give an extension of time to have mediation. Yeah.
Yeah, well, thank you for the explanation, but I would like, when we return, to broaden mediation, not only to the courts, but what happens, as you described, in the early days with African and Asian communities.
The Dominica Olympic Committee has a vision to secure medals at an Olympic Games and to bring honor and recognition to the nation. And DOC is on a mission to promote Olympism and protect the independence of the Olympic movement, represent the International Olympic Committee, live the principles and values of the Olympic movement, develop and protect athletes, promote women in sport, anti-doping, fair play, sport for all, the environment and culture, non-discrimination and education. Our logo, national colors, red, black, and green. Red, 10%, black, 30%, forest green, 60%. Support the Dominica Olympic Committee and engender national pride.
The website of the Dominica Olympic Committee, www.doc.dm. Yeah, interestingly, Mr. Compton, I sort of hung on to something, although not, but it has aspect of mediation in law in terms of our jury system, because jurors are not usually or invariably they are persons in the community who are not trained lawyers, yet they are there in court to help the decision-making process on any case, etc. Particularly in our high courts, the jury system. So it has an element, you may say, of mediation in terms of people in the community who can be mediators and they don't necessarily have a law degree.
Well, not strictly speaking, if I should intervene there,
yes.
Essentially what jurors do in court is to assess facts.
Yes.
So the jurors, what they do, they listen to the facts of the case and decide based on the facts of the case whether this person is guilty or not guilty. And the law has to be explained to them, if there is any doubt, by the judge. So you apply the law to the facts of the case. So really they're not serving as an umpire, as it were. If anybody's an umpire, they would be the judge. So slightly different there. I would just say with respect to the mediator, he has a more pivotal role to play, looking at the law with respect to the issues there, as well as almost like a mini judge, you could say, as well as understanding the facts on both sides. And like I said, the emotional part of it always comes up, because sometimes we bring a lot of emotion into it, and you have to be able to decipher, as it were, what are the facts from those emotions, and separate the emotions from it, and make it clear to the parties involved that this is not really a fact, but this is an opinion of yours, and how you discern those things and deal with it without aggrieving the person who has brought a bit of emotion into the facts is a skill. So that's very important. But if you don't mind me making that other point, I think what I like about the mediation exercise, and Mr. Compton may bear me out on this, is the informality involved, formality and informality. Much more informality at the mediation level as compared to the court. There's much more formal procedures in court, and of course much more expense. Whenever you go for the litigious route. With the mediation, it's much more relaxing, it's much more engaging, it's much more interactive between the parties and the mediator. The court formalities are dispensed with. So you tend to get a lot more done, and there's tend to be much more interaction between the parties and the mediator. That's why I think it's better to go that route, depending on the issue, because you tend to, you most likely will get at a resolution much faster than all the court formalities going through the lawyer and the lawyer explaining and having the parties to come and be examined and cross-examined. This is quite involved and engaging. So the mediation route is first of all, is more cost-effective, it's less time-consuming, it is more engaging, and the opportunity to arrive at a resolution is much faster, in my view, because whilst the lawyers are there during the mediation, Mr. Compton will bear me out on this, the emphasis is not so much on the lawyers, it's really on the parties and hearing from the parties what are the issues, The lawyers are there to back them up and to intervene occasionally, but really it's to hear from the parties, because once you bring in other parties, which are the lawyers, we all know the skill of lawyers and what they are capable of doing, or we are capable of doing, and in terms of representing their interests, the interests of the client. So, but when you hear directly from the parties involved in the dispute, and the mediator hears it, a lot of the thrills and the middle intervention can be cut off, and with a view to arriving at a resolution to the dispute much more expeditiously.
Okay. So thank you for that input. But what I'm curious, I want to kindle the interest of non-lawyers to be mediators. Dominica, like St. Lucia, I'm not competing here, but I'd like to see some, at least 100 mediators in Dominica, and they should be known, so that beyond court battles, etc., other disputes that occur, say, with trade unions, with the workplace, in the home, etc., you become a trained mediator. People know that you have that skill, and hence they approach you to help in mediating and resolving a problem that exists. But before we go into this, Mr. Compton, what I'd like you to do is, what is the process of mediation? What are the stages of mediation? What do you do as a mediator?
Okay.
So that too will kindle the interest.
All right. Before I answer that question,
yes,
I would like to say that I endorse all what Ossie Walsh has said about...
For fear of litigation? But that's all right, that's all right. Remember, Mr. Walsh there is in the capacity of a lawyer too, you know.
Right, and I also want to say that we in the region strive to train as many non-lawyers as possible. Many lawyers see the benefit and the value of mediation, so they offer themselves for training. But in St. Lucia, for instance, we have many more non-lawyer mediators who mediate than lawyer mediators who mediate. And in fact,
what sort of percentage?
There are some law firms who prefer a non-lawyer to mediator. Now, there is something that has caught my attention. And please remind me of the question that I have to answer.
Yes, yes.
And I must say this, because I have heard, even here in Dominica since I got here, that some lawyers indicate that the matters they have to mediate have too many intricate legal matters to deal with, and a non-lawyer mediator cannot mediate. And my immediate answer to this is, we have trained persons to mediate and to work towards resolving disputes between parties, not necessarily resolving legal implications and legal matters. If you want your matter dealt with, or if you want legal matters dealt with in your issue, you would go to the courts.
Yes.
But in going to the court, bearing in mind, and this is entirely addressed to lawyers who may be listening to your program.
All lawyers listen to the program.
When you go to the courts, and you know the practice direction makes provisions for court management, for case management. When you go before the master or the judge for case management, the master or the judge is fully aware of the legal implications in your case.
Yes, yes.
But they also recognize certain other aspects of the case. And if they have made a decision that this matter could be dealt with at mediation and send it to mediation, they would know that the mediator ought to be able to resolve this. Because in mediation, we are not concerned about the legal implications. We're not concerned, we will take that into account.
Yes.
You see, but we are not concerned about the legal implications because the forum for dealing with that exists.
Okay.
And if you want an amicable resolution of your dispute, whatever the dispute is, whether it be an engineering problem, a contracting problem, and what have you, the mediator will resolve the dispute. They will not tell you what to do to remedy the defect in your house. But if you have a dispute, they will work with you to help you and empower you to arrive at a decision which suits your interest. So mediation is interest-based and concerns-based. You know, the mediator is trained to listen to the facts, and based on the facts, and the mediator is trained to look at people and watch the emotional display, their demeanor, their body language, and so on, and they work with persons. The mediator is not a decision maker. The mediator is somebody
Dispute facilitator.
Facilitate negotiations between parties.
Almost like what we say in sports, a coach. But I would like you to address the stages. Because you have convinced me that I can be a mediator, and anybody out there can be a mediator. If well trained.
If
well trained, very important. Very important.
Let me make an appeal. Give me a little bit of
leeway.
Space here. What I would like to see happen here in Dominica, and you promised to help me, and I really appreciate this. We want to get some contractors, some builders, some engineers, some quantity surveyors, some ex-school teachers, ex-school masters, in fact, people in the community who have not been trained as lawyers. We want to get a whole cadre of these kind of, in fact, there are few enterprises where there are as many disputes or likely to be as many disputes as in the contracting or the building industry, you know, or construction generally. Exactly, so we need some of these.
Let me reassure you, Mr. Compton, we will get.
You will get.
With the help of the University of the West Indies,
I appreciate
the premier institution in the region, promoting education, we will work with you, Ossie Walsh, and have soon, probably in May, early May to mid-May, we will have at least, we need at least 30 persons to attend such training. It will be at a cost. I can give you a rough idea. It's in the region of around 3,000 EC dollars. That would be for 5 days of training, 8 hours per day. And when you're through with that, you'll be certified not only by the OACS Supreme Court, but also the University of the West Indies, your favorite university.
But that price also includes
your
meals, your literature, and everything.
Any workshop where you pay a package and you have to be there for 8 hours per day for 5 days must include meals.
And I must also insist
about
that anybody who wants to do that program must be prepared to devote a full 8 hours and 5 days.
Well, if you know UWI accreditation, when the number of hours, contact hours are given, you have to satisfy more than 80%.
That's right.
That is a given. So they would have to be there.
We're looking for 100%.
100%, yes. We'll be aiming at that.
Now
the processes of something, if you can briefly tell us.
If we look at the process, basically, when the mediator is appointed and the mediator is appointed by the parties, the court keeps a roster of court-connected mediators in the courthouse and in the Office of the Mediation Coordinator. So parties to a dispute will have access to that. During case management, if the master or the judge suggests strongly mediation, they will let you see the roster of court-connected mediators, and the lawyers will guide and assist the parties in selecting the right mediator. There may be some input from the master or the judge as well to deal with the particular case. Now, a mediator is not necessarily trained to deal with a particular case. I want to stress this. A mediator is trained to deal with disputes, any type of disputes, okay? Because if during the resolution of the dispute, the mediator feels or finds out that you need some kind of expert to deal with a certain issue that neither the lawyer nor the parties themselves have dealt with, then the mediator can ask that we appoint a mutually agreed to technical person. So that you can get a reason. So the mediator does not have to be a lawyer or does not have to be an engineer to resolve an engineering or legal issue, okay?
Fantastic.
Because, and not only that, during mediation, the mediator is flanked by 2 lawyers very often. You follow. So if there are things to be dealt with, the mediation process allows for what we call a caucus. That's a private meeting within the bigger meeting. So things like this could be discussed, but the process. Remember, Mr. Walsh indicated that the mediation is, he may use slightly different words, but the mediation process is user-friendly. It is less formal. And there are a number of things you can do and say during a mediation process that you cannot do and cannot
Inadmissible
say
in court.
That's right. You got it right.
Yes, yes.
Okay? So the mediator, his job is to make the parties feel comfortable and relaxed. So he will meet the parties, because we're looking at the process. He will meet the parties, greet them, bring them to sit, and usually, and I hope many persons in Dominica who mediate will remember this, the dispute is between two parties, not between two lawyers. It is true that the lawyers have to take care of the interest of the parties, but the dispute is the parties' dispute, not the lawyers' dispute. If the lawyers go to court, it becomes their responsibility to defend the client.
Yes.
But in the mediation, when the mediator introduces and brings the parties in, the mediator will traditionally and ought to put the parties to sit next to him, closest to him, and the lawyers further away.
Yes.
And the mediator will make, apart from introducing himself as a mediator, not as an engineer, and he doesn't have to give his qualifications, otherwise his only qualification which matters at that time is, I am a trained mediator on the roster of court-connected mediators. That's my only interest, nothing else. Now you've allowed me to tell people that I was involved in Social Security, but in a mediation session, that's not their business.
Yes, yes.
That's not part of what is expected of me. You are a mediator, and your job is focused on this.
Your expertise is in mediation,
That's
not
right.
in
Not
engineering
or anything
construction.
else. Right. You are not allowed to advertise.
Divorce experts, etc.
You are not allowed to advertise your other skills.
That is understood. So there's an introductory phase, and you set the seating arrangement, which is
right.
user-friendly.
And the greetings and
Yes,
so on and so on. And you assure people in the process that, you know, unlike the courts, we've provided some tea and coffee. This is expected, so that at any time, feel free to get up. You know, you don't have to bow, you don't have to ask me for permission. You get up, you know, walk around, you know, while we work at it. But after all that is done, and the mediator will also explain to the parties what mediation is. It's a voluntary process, it's an informal process. I am an impartial person. You know, the mediator will have a little conversation to explain and define what mediation is all about, okay, to the parties. Now, all this time, what is happening is he is gaining the confidence and the respect of the parties who are before him, and he's also using that opportunity, without expressing it, to make the people feel comfortable and happy. And he takes some time to explain all these things, tell them that there will be a need for a caucus and so on.
They are put at ease. Next
At
stage.
ease.
Not that
next
we
stage-
want
no,
to
no,
reveal
but next
everything
stage,
so that persons choose, well, I've heard Mr. Compton on TV, and that's what mediation involves, so then there's no need for me to come to this workshop. Their appetite, you are whetting appetite. So what happens next?
Next, after they settle down, the mediator will begin to hear their stories or their problems. So the mediator will decide which person speaks, because he has to control the system. So he will ask this person, could you tell me, and the question that I ask as a mediator, can you tell me in your own words? Now, but you have to make sure that this person has to speak for himself and not his lawyer.
Yes.
Because although the lawyer will speak and they're
support.
but it's the parties' dispute and they must speak and represent themselves.
Yes.
So can you tell me in your own words, what happened or what you see happened to cause you to come here today? And all I want you to explain to me is that aspect. And what would you like to see happen here today, so that tomorrow you will be better off, or you will be able to live better with your neighbor or your person who you. So that's the question you ask to one party, and you ask the very same question to the other party. okay, after the first one has spoken. So you'll sit back and listen. That's what the mediator does.
Yes.
And everybody else will listen without interruption, traditionally, except if the mediator wants to clarify some issues. So the person speaks until the person has exhausted what he or she has to say. And what, as a mediator, I would expect, before you let this person go.
I'm like, you know, a good mediator. I've listened. We will be back.
I'm part of a tough, smart,
Constantly evolving,
never too old to learn community of human beings.
proud of country,
Proudly Caribbean, global citizens.
with convenient access to over 400 learning programs
Delivered both online and face-to-face.
from the Caribbean's University of First Choice.
My mind,
My life.
my world of possibilities is wide open.
Call, click, or visit the UWI Open Campus.
Yes, the University of the West Indies Open Campus Dominica site has a role to play, along with, and we will be working with the registry for the registrar, Ossie Walsh, and his team at the registry. But we are definitely aiming to stage a workshop to get more and more Dominicans qualified as mediators, because this, as we understood tonight, is very much needed. And what I do usually in wrapping up, because Mr. Compton has, at least I know for sure, whet your appetite of who a mediator can be. It can be you, and not necessarily some expert engineer or some lawyer or some doctor or, you know, some professional person. We all can, because that's what happened in villages in India, in Africa, where the village elder, the man with wisdom, the woman with wisdom, would help to resolve disputes. So we will, in May, early May, mid-May, be calling on Dominicans. You listening and viewing this program, register today. Mr. Walsh, I think that what we have spoken about, people will still be debating the issue of what impact will that have on the legal fraternity in Dominica. If our number of mediators were to increase, would that eat into the profitability?
I don't think so at all, Mr. Chairman. In fact, I think by and large lawyers have embraced mediation in Dominica. I understood there's the thinking now of even before the litigious route starts to consider mediation. But that's down the road if the Chief Justice, in a wisdom, so decides. But with respect to court-connected mediation activities, the litigation process must kick off first. In other words, someone has to file a case in court. And on the basis of that case, and once the process has started, then the parties involved, either one of the parties or the parties collectively, can decide at an early stage of the proceedings, then they would like to opt for mediation, or when the matter gets to case management, the master of the court can decide, well, this matter could go to mediation, or the parties could then decide, or when it actually goes to trial. So what I'm saying is, at any stage of the proceedings, a matter can go to be referred to mediation at any stage of the proceedings. So, and lawyers are involved in the stage, in those stages. So, and some of the lawyers themselves are mediators. Yes. So I don't see how it's going to have, or it having any negative implications for lawyers. I think it complements lawyers' work, and it's another avenue to resolve a dispute. Yes. And by and large, my experience here at the court is lawyers have generally embraced mediation in Dominica, and it is alive and well here, based on the results I'm seeing at the court.
And also, Ossie and Mr. Compton, where mediation, I think, is being practiced and has been, I hope it is recognized that way. If industrial disputes, you have what is called a tribunal. Yes. That is where the parties, the union on one side representing employees and management, they try to resolve things before it goes to court. In fact, even in sports, which I'm involved in, we have what is called the court of arbitration. Okay, there are several stages before we get there, before it goes into the legal framework of going to court. You can have disputes, you know, with athletes and the managers, the handlers, etc., and that could be resolved locally or regionally, and ultimately the court of arbitration, usually with these cases involving doping and so on. So that's happening. That is being different. You said about alternative ways of resolving disputes. So that is happening.
Yes.
But here it is. You've been called upon to be trained mediators. But I'm going to ask that question to both of you. Who monitors the activity of these trained persons? Because I can be trained, and a month down the line, I'm never called, a year, I'm never called to mediate in anything, and I hence lose the skill. That's why you are here to revive persons who are mediators, who monitors, and what measures are taken to monitor that you as a mediator remain the top of your skill.
If I may start.
Yes.
When we train persons to mediate, we tell persons at every program that we run that we are seeking to impart a life skill which can also be, for many persons like myself, a life-changing opportunity. And we tell them that even if we train persons to operate at the level of the Supreme Court, we don't train persons only for the court. We impart a skill, and we expect you to use that skill and practice that skill in the workplace, in the home, in the community, in your environment.
Yeah, but what I'm getting to, Mr. Compton, is that is what you say to people.
Yes.
We may listen or we may not. But having been trained, is there a mechanism to evaluate the level of your expertise as a mediator? Ongoing, that is continuous, as well as...
Categorically, yes. The reason I say yes is that we have two things. Unfortunately, we have faltered a bit in Dominica, but people have promised that they will put it right. The mediation program also allows for a mediation committee.
Okay.
And that committee is made up of specified persons from the community. And we have maybe a representative of the church, a representative of the union, and a representative trade associations, you know, things like, persons like that. And traditionally within the OECS, the resident judge has been the chairman.
So you're saying that a committee like this should be set up, say in Dominica?
No, it is. There's legal provision for such a committee at a practice direction level.
But is that committee in Dominica functional?
That committee is being revamped at the moment. It's being revamped at the moment. But I would just compliment what Mr. Compton is saying by saying that there are different forms of evaluation or monitoring, and that is the administrative level. But even at the individual level as well, I would expect a mediator, if he or she would like to be someone, as it were, who is identified by persons to lead the way, to resolve matters, to do their own personal development and keep improving yourself. You know,
but
so you will stand out as a person.
One thing that could help, apart from the committee that Mr. Compton made mention of to oversee the mediation community, I would think mediators who are trained and are purpose-driven can form a little association.
Yes.
And hence have among themselves, you know,
but if you permit
exchanges
me to say one thing that is
to sharpen their skills,
vital in answering
and
your
you'll have
question.
just 30 seconds to say this.
In answering your question, is we have designed and devised what we call appraisal forms.
Yes.
Appraisal forms which are presented at the mediation session.
Yes.
And the appraisal forms for the litigant, both sides, and the appraisal forms for lawyers, both sides.
Yes.
And those forms are filled in. There are certain questions asked, and those forms ought to be retrieved at the end of the mediation session and sent to head office in St. Lucia, where we have a statistician who can analyze those forms and indicate to us how the process is working in Dominica. Unfortunately, that has fallen down
Yeah.
to some extent. But all these things will revive.
I can reassure you, the University of the West Indies, and particularly the Open Campus in Dominica, will help to put that. And
Thank
anything
you
that
very much.
involves this evaluation form that you mentioned, I know UWI has had a hand in it. Welcome to, I mean, you have been welcome already, but this is the end of our program for March, and look forward to April, the third Thursday of the month.
Thank
you very much. Thank you very much, Mr. President.
Yes.